Hi, I'm immigration attorney Ricky Malik, and today I'd like to talk about exemptions to the English language requirement for U.S. citizenship. Oftentimes I meet people who want to become U.S. citizens but cannot or are unable to learn the English language in order to pass the U.S. citizenship and immigration test. For those people, they have to look to determine whether they fit in any exceptions that are available that may permit them to either not take the test or take the test in their own language. There's, first of all, several built-in rules. The most commonly known are the 50-20 and the 55-15 rules. That is, if someone is 50 years old and has been a U.S. lawful permanent resident for 15 years, then they can take the test in their own language, or they're not required to demonstrate an understanding and usage of the English language. Alternatively, if they are 55 years old and have been a lawful permanent resident for at least 15 years, they can qualify as well. Another lesser known rule is, and this is more discretionary, but if someone is 65 years old and has been a permanent resident for 20 years, then not only may they take the tests in their own language, they may even be exempt altogether from the civil test completely. Now, for other people who don't qualify for the age and residency duration exceptions, they may seek a medical disability waiver, commonly known as an N-648. Now, this process is more complex and requires that the person demonstrate with the expertise of a qualified physician or doctor that they are unable to learn the English language. Now, many people try to do these, and oftentimes the problem is the N-648 completed by the doctor is not comprehensive enough in order to satisfy the immigration officer that this person cannot learn the English language or learn enough knowledge of the history and civics to pass a test. So what I'd like to talk about are what specifically is required in an N-648 waiver provided by a physician that will satisfy the requirements for the immigration services. Firstly, what really needs to be done is there needs to be a comprehensive finding of what is the specific problem. There's something called the DSM-V, that's the Diagnostic and Statistical Manual of Mental Disorders. The doctor has to be able to classify that the person falls within one of the DSM-4 mental disorders. Secondly, there needs to be a detailed explanation of how this disability or impairment affects the applicant and prevents him or her from learning or demonstrating knowledge of English and or U.S. history. And this is very important, that there has to be a clear explanation. Further, the doctor's conclusion whether the applicant is able to learn or demonstrate knowledge, learn English or demonstrate knowledge of U.S. history and facts must be documented with a clear explanation of the origin, of the nature, and the extent of the medical condition, including the test that doctor employed to determine that this person, this applicant, cannot learn the English language or learn the civics and history components as well. Then further, the doctor must explain how the medical condition or impairment severely affects the applicant in regard to the required tests. Further, the doctor then must attest that this condition is expected to last 12 months or longer, and finally, that this condition did not arise out of the use of any sort of illicit or illegal drugs. Those are the main components of the N-648 waiver that need to be comprehensively conducted, ethically conducted as well, by a doctor to truly analyze, is it this person has a mental disability, a disorder that prevents them from learning a new language. Oftentimes, N-648s are denied. And I oftentimes meet clients that come to me after their initial denial, and I ask for a copy of the N-648 waiver, and it may have just been handwritten by a doctor and not given enough detail or effort. It's a very serious application and form. Requiring a waiver of the English language is not taken lightly at all by immigration, and therefore, if you do want to seek a waiver outside of one of the 60 or 55-year requirements, you have to have a thorough analysis, and you really must have some sort of mental disability or disorder in order to qualify.